Good afternoon and welcome to our autumn GDPR and data protection update. For those of you who don't know me, my name is Martin Sloan. I'm one of the partners in the commercial services team at Brodie's and will be presenting today alongside my colleague Grant Campbell. In terms of what we're going to cover for those of you that haven't joined us before, the format usually is we go into a couple of issues in depth, and then we will talk about some of the other events that have been happening over the last 6 months or so. And I think it's fair to say, as it seems, I seem to say, as every 6 months on this webinar, there's been a lot going on and a lot to cover, a lot to catch up on. So what we want to do today is talk a little bit about data protection reform. You'll be aware that the Department for Digital, Culture, Media and Sport has proposed changes to UK data protection law. So I'll kick off by talking a bit about proposed data protection reform. I'm then going to hand over to Grant, who is going to talk about international transfers, and he's going to cover that both in relation to what's going on in the UK, but also the EU as well, and that will follow on from our previous updates where we talked about changes in the EU side. Grant will then hand back to me, and I'm going to talk a bit about data breach claims, including Lloyd v. Google and a couple of other cases, and then we'll hopefully have time just to go through a couple of other things that have been happening that you may have missed, and then some time at the end for questions. So please do put your questions in the Q&A, as I say, and we can pick those up at the end. So to start off, yeah, I was going to talk a bit about data protection reform, and I've said here, you know, that this is the start of divergence. Obviously, post-Brexit, UK data protection law was a copy and paste of EU law, but we are now starting to see what the UK government thinks it might do now that it has the freedom to vary data protection law in the UK and potentially diverge from what is going on in the EU. And Graham will pick up on that theme in the context in particular of data transfers. But we had earlier this year a consultation paper published by DCMS. It's essentially a wish list or a kind of an options paper of things that could be done. I'll talk a bit about that on the next slide. But what we tried to do here is pick out some of the key themes you can see in the paper, and where changes might take place. The consultation closed last month, so we're now waiting to see what response was provided and how the government will take forward its proposals. But just running through those different topics. So the first one, and this is the one which will impact on everyone on the call, is around accountability. So DCMS is proposing that the GDPR accountability framework that we all know, I was going to say know and love, but at least we know it, and we spent a lot of time getting to know it and integrating into our organizations, would be replaced with something called a privacy management framework. So privacy management program, and that would remove a number of the express requirements under GDPR in relation to things like the carrying out data protection impact assessments and the appointment of DPOs, with a proposal you'd instead appoint a suitable individual to manage your data protection compliance. Likewise, some of the specific requirements around record keeping would also be removed. And I'll talk about this in the next slide, but essentially the privacy management framework would be a sort of, you work out what is right for your organization approach. And when you unpack it, actually query whether anything actually is changing here, because I suspect for most organizations, their privacy management program would just look like what they've implemented for GDPR. Why would you re-engineer it all just because you have the ability to do that? So slightly odd proposal there. I'm not sure what that actually does in terms of helping organizations. It seems to take away one thing and then replace it with something which is much vaguer, but we'll talk about that in the next slide. In relation to data transfers, so there is a proposal that exporters would be able to determine adequacy. So you may remember that under the 1998 Act, there was an option for an exporter to essentially make its own finding of adequacy around the arrangements it put in place for a transfer. That was removed with GDPR. It was a UK thing, and DCMS is consulting on whether that should be reintroduced to give exporters more flexibility, but also probably more accountability in terms of decisions that they make. There's also a suggestion around expanding the use of derogations under Article 49. So that's things like the ad hoc transfers, things like relying on consent and some other things for occasional transfers and broadening that out. and also to encourage the use of certification schemes, which we're now starting to see come through. On subject access requests, the consultation asks whether there should be some form of cost limitations. So that would allow organisations to refuse a request where it's going to cost them over a certain amount to respond to. And DCMS has suggested you could have an FOI style cost limitation programme. For those of you that are in the public sector, you'll be well aware of that. Query whether that works in the context of individuals exercising their rights about their personal information. But it is something which I think will get a bit of discussion, because certainly compliance with DSARs is costly for a lot of organisations, particularly when they are on the more sort of spurious or vexatious side, but there's not a clear right to reject because you don't perhaps have sufficient evidence to reject it on the basis of it being manifestly unfounded. On ePrivacy, this has been well trailed and there's been a lot of discussion about this in the press, but there would be a removal of the need for consent, certain types of tracking, so analytics cookies, and what are termed low-risk trackers or low-risk cookies. The devil, I think, here is very much in the detail as to what actually falls within that, but the intention seems to be to try and tackle cookie banner or cookie consent fatigue by removing the need to do that, as opposed to perhaps looking at what needs consent and improving compliance, which perhaps is the better way to look at this. So we'll see where that one goes. One thing for those of you in the charities and third sector, there is a suggestion that the soft opt-in could be expanded to be used by charities, which I think charities would welcome. It's always felt a slightly odd thing that they are not treated in the same way as say a retailer, though that would also apply to political parties. So it's a double-edged sword that we may all start getting a lot more marketing from political parties, which I'm not sure everyone would necessarily welcome. On legitimate interests, there was a suggestion there'd be a whitelist of activities, and the idea with this is that you wouldn't need to carry out your legitimate interest assessment balancing test. You could say, well, we are doing this activity, and therefore we don't need to do any further assessment. It's clearly something where we have a legitimate interest. And that, I think, is helpful in terms of reducing the compliance burden. But again, the devil's in detail as to what's actually on that list, and whether actually the activities that are on that are specifically clear that actually people can rely upon them, or whether they are written in quite a generic way that means you still need to do a test for your particular organisation. So an interesting proposal, I think. It will very much depend on how that's taken forward. On AI, there is a proposal to remove the Article 22 right. So that's where if you have an automated decision about you, you have the right for a human to review that, which is causing a bit of concern, given the increased use of AI and the accountability issues there in terms of understanding why decisions are made. There's also some proposal around here around using data intermediaries and data sharing, which will be helpful for the development of AI, and also some clarifications around when data is considered to be anonymous and how you assess that compared to the current rules. On research, there's a proposal to define scientific research and also to add a new legal basis under Article 6, so that's your non-special category processing. So rather than it being either legitimate interest or a task performed in public interest, you would have a specific scientific research legal basis. So that may be helpful. And also broadening out the ability to reuse data where there's an overriding general public interest. So this is about the purpose limitation, where you perhaps didn't collect that data for the purpose of research, but you want to reuse it. Again, I think it needs to see where that one goes in terms of how that policy objective would be developed. And then the final point is just around the Information Commissioner. So there are proposals to give it some new powers to merge its functions or bring in the functions of the biometrics and surveillance camera commissioners to the ISO as well, which the ISO has welcomed a number of these things, but also some changes to structure, which including the powers of DCMS, the Secretary of State, which the ICO is concerned may impact on its independence as a standalone independent regulator. So I think you see from that this is very much testing the water. I was on a round table with someone from DCMS last month, and they described it as being a mix of white paper and green paper proposals. So some things are concrete proposals, others are more for discussion, and I think we're very much in the early stage in terms of how this is taken forward. So a fairly mixed response from the ICO. It welcomed some bits of it, but other bits it has raised concerns on. And I think for for most people who are on the call, some of the clarifications will be welcome. But my feel is from certain clients I deal with that no one is looking for radical change. Everyone spent a lot of time and money back in 2018 implementing GDPR compliance frameworks, and no one has the appetite to spend a lot of money to redo those. Unless there is any clear benefit for that. And as I say, I don't think the proposals actually really make much of a change. And if you're multinational, you'll want consistency across your business. You don't want a UK framework and a separate one for the EU. You will want consistency. At the other end of the scale for SMEs, yes, there's more flexibility. You can have a program that perhaps better affects your organization, but that means greater ambiguity, so more uncertainty, and then you've got to spend more on external advice to work out what it is you need to do as a business. So again, query whether that is actually progress there. Does it have an impact on the adequacy decision we have from the EU? It very much depends on which of these proposals go through. I think a lot of it probably won't have much of an impact, but there may be some things in there that do cause concern, for example, particularly around data transfers and the onward transfer of EU data. So we shall see what happens in terms of next steps, but we will keep you posted as we get the next step in these proposals. So on that note, I will hand over to Grant, who's going to spend the next wee while talking about international transfers.
Afternoon, everyone. This, as Martin said, is a fast-moving area. It's fast-moving, I guess, for two reasons. One is post-Schrems 2 fallout, which happened a little while ago and has caused a number of changes to the international transfer regime, and also as a result of the UK being decoupled from the EU and therefore able to think for itself. So what I want to do is talk a little bit about, firstly, the UK perspective, so transfers from the UK. So the UK rules apply where the processing of personal data is governed by UK GDPR. And for those of you who are with us in May, you'll recall that I talked quite a lot about the two parallel regimes. So here we're talking about UK GDPR processing. And under the UK regime, transfers are permitted to countries covered by the UK adequacy regulations. So we've got a UK adequacy regime, which is aligned with the EU to a certain extent. So any country within the EU, you can freely transfer data. Any country covered by an EU adequacy decision, as at the end of the transition period, so 31st December 2020 is covered. And then there will be further adequacy decisions issued by the DCMS with input from the ICO. So that is the adequacy regime that we have within the UK. Where there is no adequacy finding, then restricted transfers can only be made subject to appropriate safeguards, which include binding corporate rules, standard contractual clauses, codes of conduct, approved certification schemes, and bespoke contracts authorised by the ICO. And then finally, if you don't have an adequacy finding and there is not a mechanism under Article 46 to give appropriate safeguards, then it can only be made if it is covered by a derogation under Article 49 of GDPR. So that kind of strata of permissions is the same as the EU. Where we start getting into areas of change are in, and I'm going to focus on standard contractual clauses. So again, this is transfers from the UK. Currently, so EU standard contractual clauses that were entered into prior to the end of the transitional period, before the end of 2020, continue to remain valid. So these are the old standard contractual clauses. Those old standard contractual clauses are still under the UK regime valid for new restricted transfer. So we can still use the old style standard contractual clauses for future transfers. And to make them valid or to make them appropriate for the UK context, to make them work, the ICO has published revised versions, their suggested UK versions, which you can get online. Now, the important point to note is for the UK regime, The new European standard contractual clauses, which were published in June, and which I will talk a little bit about later, are not valid under the UK regime. So the new style standard contractual clauses introduced in Europe are not valid under the UK regime. In parallel, the ICO consulted in the autumn, and it was a consultation that ended in October, on a new draft international data transfer agreement, an IDTA, and alongside that, an international transfer risk assessment and tool, which I'll call the transfer risk assessment. Now, the intent is that this IDTA will replace the old style EU standard contractual clauses as effectively the UK's equivalent to them. The ICO has also proposed a UK addendum that can be used as a wrapper around the new EU standard contractual clauses, but that again is just a consultation at the moment. The TRA, the transfer risk assessment, is bluntly the UK's equivalent to the EDCB's guidance on supplementary transfer tools, which I will talk about later as well. So we have this TRA and the IDTA. The consultation also covered the interplay between the extraterritorial provisions under UK GDPR and the international transfer provisions. So that's where you've got organisations outside the UK, and whether or not you have to put in place these restricted transfer provisions if they are governed by UK GDPR. So this consultation has closed. What we don't know yet is when the outcome of that consultation will be made public, and we don't know what the timetable for implementation of the new contract and its form is likely to be. And so if you are currently thinking about putting in place standard contractual clauses, you're currently restricted to the old EU ones, sorry. And the question is, if you're doing that, then you probably need to think about contractually binding whoever you're dealing with to move on to the new ones. So onto the transfer risk assessment. So this transfer risk assessment is a companion to the data transfer agreement, and it's designed to help organizations assess whether the IDTA will offer protection to data subjects to a standard which is sufficiently similar to that enjoyed in the UK. And sufficiently similar is the phrase that the guidance uses, and it is intended to mean essential equivalence, which is the phrase that came out of Schrems and which is what the EDCB mentions heavily in its guidance. So the ICO thinks that's the same test. But the ICO has said that their aim is to come up with a system which is proportionate and risk-based. And the guidance contains, so the risk assessment contains a tool which is intended to give practical guidance to organizations as to how to make the assessment. If you read the guidance though, the ICO is clear that the tool only works for what it considers to be routine, i.e. not complex and not high-risk transfers. What does it mean by complex and high-risk transfers? Well, it gives a number of examples. So it says if you're transferring data to an importer that is governed by a number of different destination country laws, then that will be a complex transfer. If the transfer is going to involve newer or novel technologies, that is likely to be a high-risk transfer. And if you're transferring data to a country which has a poor human rights record, and that human rights record may be relevant in the context of the relevant transfer you're making, again, that may be a high-risk transfer. And so what the ICO said is this tool wouldn't apply in those circumstances. You will need to do further, more detailed analysis. And actually, if it's a high-risk transfer, you will probably also need to do a DPIA. So there are limitations to the tool, but it is a useful tool for organizations that are considering international transfers from the UK regime. Now, the tool provides itself for a three-step process. So the first step is to assess the relevant transfer itself. So that means looking at the relevant transfer details, where is the data going to, who is it going to, where is the importer located, will the data be transferred on, what types of data are we talking about, the whole host of things that you would normally be thinking about in the context of the particular transfer. And you also need to think about, actually, does this transfer otherwise meet the more general requirements of UK GDPR? So that's in areas like the lawful basis for transfer, security, transparency, all of that sort of stuff. So that's step one, looking at the actual relevant transfer itself. Step two in the process is, will the IDTA likely to be enforceable in the destination country? And the ICO says, look, we don't expect you to become an expert in all of the laws of the country of destination, nor are you expected to cover all of the same ground that the UK government will do in deciding whether that particular country offers adequate protection for an adequacy decision. So you would look at publicly available information about the legal system and also ask the relevant questions of the data importer, so that the data importer has to disclose to you all relevant information about the local laws. But what the guidance also said is, look, even if you have some concerns about whether or not the IDTA may be enforceable in the destination country, that is not necessarily fatal if there is no risk or a low risk of harm, given the type of data being transferred, other factors relevant to the risk, and any extra steps that could be taken to safeguard the data. So again, this comes back to the proportionate and risk-based approach. You look at the relevant transfer, what you're trying to do, and think, actually, even if there are maybe some issues around the enforceability of the IDTA, is that likely to create more than low risk of harm to the data subjects? And that may involve supplemental analysis beyond the headlines. The final step is looking at things like surveillance. So is there appropriate protection against third-party access? But again, the guidance says, look, actually, this step may not be necessary if the risk of access is minimal and in the context of the particular data being transferred. And even if it were to happen, the risk of harm to the individuals is low. So you can see when you look at these three steps, that steps 2 and steps 3 recognize a risk-based approach in terms of both probability of harm and actually the likelihood of significant harm. But I think that the important thing to understand here, this isn't a soft touch regime. You will have to document the reasons for considering that actually there is low harm or low risk of harm. And you will have to put that down in a form that actually you will be able to stand behind if you use the IDTA and there are questions that are actually raised. So moving on to the International Data Transfer Agreement, the IDTA. So again, just to emphasize, this is to be used when the processing activity is governed by UK GDPR. And I, again, just mentioned that as part of the consultation that the ICO conducted in the autumn, it's reviewing its current guidance as to whether particular transfers actually engage the transfer regime based on whether GDPR, the extraterritorial provisions in GDPR may or may not engage in relation to the parties outside the UK. So we will get greater clarity on that from this consultation exercise. And that may affect when IDTAs are actually do need to be employed. But looking at the IDTA itself, a number of things struck me. Firstly, it's multi-relationship, so it can be used to paper a number of different relationships depending on the relationships between the parties. It can be used on a multi-party context, so it can be used to paper agreement if there are more than 2 parties to it. And it's provided in a template format. And I'll talk a little bit about the anatomy of the IDTA on the next slide. But that template format doesn't need to be used so long as the prescribed information is included and the mandatory clauses incorporated. But the important point is the IDTA needs to be used in conjunction with the TRA, because the TRA will determine whether or not the IDTA is an appropriate solution for the transfer. In terms of the IDTA itself, so the consultation included a draft IDTA, which contained a whole load of legal clauses in it. I'm not proposing that we go through all of those line by line today, in part because it may change. So it's out to consultation. I am sure that some of the terms will change, but to run through the anatomy of the IDTA that was published, started off in part 1 with tables, which covered the parties and signatories, the transfer details, the details of the transfer data and the security requirements. The ICO said it's not mandatory to use these tables, but you must get the prescribed information into the agreement that you put in place. Secondly, the second part is for extra protection clauses, and this is where the TRA comes in. So as part of your TRA exercise, if you determine that you need to add in additional clauses to cover technical, organization, or contractual protections that you think are needed beyond what's in the style IDTA, part 2 is the place to put them. Part 3 is reserved for commercial clauses, which is entirely discretionary. The IDTA recognizes that commercial clauses may actually be included in what is known as a linked agreement, or they could be embedded in the IDTA itself. But where you've got a linked agreement, the important point to understand is the IDTA overwrites any inconsistent provisions in the linked agreement. So again, this is about ensuring the primacy of the safeguards that are being put into the IDTA, so they will override any provisions to the contrary in the linked agreement. And then finally, you've got the mandatory clauses in part 4. And as you would expect, given the name, there is very limited scope to change those mandatory clauses. You can change cross-referencing, you can tailor it to meet any changes to the table in part 1 where those are permitted, and you can adapt them a little bit if you've going to use them in the context of a multi-party agreement with more than 2 parties. But beyond that, these clauses are pretty much set in stone. So those terms cover quite a lot of things: the adequacy and effectiveness of the safeguards, the requirement for periodic reviews, the obligations of both parties. I'll talk a little bit about that in a second. Onward transfers, honouring the rights of individuals and how they exercise those rights. How you handle local access requests under local laws, how you terminate the contract, how long it lasts, and what happens to liability and legal claims. And then there's a defined glossary, there's a glossary of defined terms at the end. The thing that I would just draw to your attention again to tie in the TRA and the IDTA is the mandatory clauses require the exporter to confirm that the IDTA is an appropriate safeguard and that it can evidence that by reference to the TRA that it has conducted. The importer contractually confirms that it has provided all relevant information about the local laws to inform that TRA, and both parties agree that their workings, both the work that's been done in the TRA and also the importer information will be made available to the ICO if it asks for it. So you need to look at, if you're employing the IDTA, the TRA could become a document that is actually disclosable to the ICO. So you need to make sure that the 2 documents work together. Next slide, please. Yeah, so I wanted to talk a little bit about the EU side of things, and this is actually probably building on a number of things that we've talked about in previous sessions. So we finally got an EU adequacy decision 2 days before the 30th of June deadline, and that ensures that data can move freely between personal data can move freely between the EEA and the UK. But the adequacy decision contains a sunset clause, so only lasts for 4 years, can be renewed for further 4-year periods. But there's a clear warning in the text. The Commission is monitoring a number of developments in UK data protection law for divergence. Martin's mentioned this earlier, but specific things are mentioned in the adequacy decision. The UK's position on data transfer to third countries, and I'm thinking primarily that's likely to be DCMS decisions to say that particular countries adequately protect data, any limitations that the UK introduces on the rights of individuals, government access to data, so this is a surveillance culture, and case law on the role of the ICO. So you can see that the European Commission will be looking closely at the DCMS proposals, because the adequacy decision says expressly, if the Commission considers that the UK no longer ensures an adequate level of protection to data, then it reserves the right to suspend or repeal the adequacy decision in whole or in part. So we have to keep that in mind as things develop. Next slide, please. Yeah, so I mentioned earlier that the new EU standard contractual clauses don't work in the UK, in the context of UK processing, but they are in place, and for those organisations that operate on a parallel regime, they are important. So these finalised EU standard contractual clauses came into force on the 27th of June. The old standard contractual clauses are still valid until the 27th of December 2022, but there will be a process of trying to migrate from these old ones onto the new ones in readiness for that deadline. A modular approach, so again, it can paper multi relationships in terms of controller to controller processor, etc. Do they address all the Schrems issues, all the issues that came out of the ECJ? Yes, but in part. But again, as with the UK, they require a case-by-case assessment of risk in the exporting country and supplementary measures to be added, which brings us to the guidance which we've trailed in previous sessions that the EDCB issued in a response to Schrems about supplementary measures. So that guidance was finalised in June 2021. It has a 6-stage roadmap rather than the 3-stage proposed in the UK, but the ground is broadly the same. But that 6-stage roadmap hasn't changed. What has changed is the approach in the final guidance is a bit more balanced, perhaps, and proportionate than the original pre-consultation draft. In particular, the guidance recognises, I think grudgingly, that in assessing the legal landscape in the destination country, where there may be problematic laws, exporters can consider whether these laws are likely to be exercised in relation to the specific transfer that they're looking to make. Now, this needs to be evidence-based, but from previous sessions, you will recall that there were a number of scenarios: use of cloud services, vendors who were subject to FISA 702, and intra-group transfers where the EDCB came out with pretty black and white positions saying, we can't envisage a circumstance in which you can do this in circumstances where the data has to be clear in the country of destination. So if you encrypt it, it's fine, but short of that, you're pretty much snookered. The EDCB guidance is now not quite as black and white as that. So you're allowed to consider with evidence as to whether or not particular laws are likely to be employed given the particular transfers that you're looking to make. Again, this guidance, this EDCB guidance now no longer has direct effect in the UK. So, but the ICO said it may provide useful background guidance. So again, it's a useful reference text in a UK context. Finally, I just wanted to talk a little bit about a new piece of guidance has been issued by the EDCB. It was issued last month in November. So this is out for consultation to the 31st of January 22. And this is about the interplay between international transfer provisions and the extraterritorial application of GDPR. And what it's seeking to do is to clarify how the provisions in Article 3 work with the provisions relating to international transfers. And what the guidance suggests, and I do stress this as draft guidance, is that a restricted transfer occurs where you have a controller or a processor which is subject to EU GDPR for specific processing. That controller or processor, the exporter, discloses that data or makes it available to somebody else, a controller, joint controller, or other processor, and that processor is outside the EU, irrespective of whether it is subject to EU GDPR. So the fact it is subject to GDPR doesn't mean it's not a relevant transfer, but it does mean only that actually the level of safeguards that need to be built in may be impacted. So you may need less safeguards, but you still are dealing with a restricted transfer. And that slightly jars with what the UK's ICO has said in the consultation paper that it put out. There are slight differences between the ICO's stance and what the EDPB are saying, but it'll be interesting to see whether there's any convergence when both these exercises are completed and the finalized guidance is issued. There are a couple of quite important things just to flag, and I think they will probably apply in both cases from the UK and the EU. So the EDPB guidance says specifically that where an individual transfers their personal data outside the EEA to a country, to a company outside the EEA, then that is not a restricted transfer because the individual is not an exporter for data protection laws. So there is no need for the restricted transfer provisions to apply. It also says that for a restricted transfer to take place, there needs to be two entities involved. So, and the example given is the one of an employee of an EU controller accessing personal data on a laptop from outside the EEA. That is not an international transfer because there is no separate legal entity taking the data. But it does say, actually, the EU controller needs to think whether that is appropriate from a general EU GDPR compliance perspective in terms of things like security, etc. So that guidance is out there. It will be finalized after the end of the consultation period, and bear in mind that similar consultation is going on in the UK, has gone on in the UK, and we wait to see what the ICO has said. So really, finally, just to draw this together, I think what I would say is the approach that the EU and the EDPB and the UK ICO have taken has many similarities, but it feels to me like we're going back to approximation of laws rather than alignment and harmonization, which is what we had when we were part of the single GDPR process. I think the UK's approach seems to be more pragmatic and risk-based. I don't think that means it's a softer touch, it's just different. Does it matter? Yes, I think it does, because I don't think necessarily the application of both regimes will always lead to the same result. And actually, I think the final thing is just to consider, bear in mind that how we go with this may well yet have impacts in terms of the wider adequacy relationship between the UK and the EU. So lots still to happen. So I will now hand back to Martin.
Thanks, Grant. Yeah, so I'm going to just spend a couple of minutes talking about a couple of data breach claim cases. Starting, I think, with Lloyd v. Google, which you may all remember from previous sessions that we've done. And this was a fairly high-profile breach. It comes in the background on the side there. I'm not going to go through it in detail, but just the development of case law around the ability of individuals to obtain damages for pure distress. So they haven't suffered any financial loss. That's confirmed back in Vidal Hall. And then trying to deal with this issue, which is that small value claims are expensive to bring, particularly when you're up against someone like Google. So how within the various court processes can you do that? Individual actions are expensive. Group actions, you need individuals to opt into that under English law. But there is a third way in terms of representative actions, and that's what Lloyd v. Google is about. So we can move to the next slide. So this is all about breaches of data protection law in relation to the Safari browser back in about 2012, where Google allegedly introduced a workaround to deal with restrictions on cookies and tracking. And what Mr. Lloyd was seeking was damages simply for the loss of control of his personal data. So it wasn't that he'd actually suffered any loss or damage, but just the simple fact that his data was being used in a way that he had no control over. He should get damages for that. And the representative action was on potentially for up to 4 million users, every one of whom had been affected in the same way. So they've all got the same interest. And he was saying they've all suffered uniform damages. So this is being going through the courts to various stages, because proceedings need to be served on Google outside the UK. They have to look at whether there's a prospect of success. And the High Court, the Court of Appeal, said, yes, actually, this should proceed. And so that potentially exposed Google to damages of, well, £750 times 4 million is about £3 billion. So a huge, if that was upheld, then that would have a huge impact on claims, not just for Google, but for any personal data breaches, cyber attacks, all that kind of stuff, where there are large numbers of individuals affected, if they could simply just get a payment for not having to show any damage. So what did the court say? Well, on the 2 points they were asked to look at, they found in Google's favour. So the first one was whether, as I say, you could have damages for loss of control. The court said, well, you can have these for a claim of misuse of private information, which is a specific tort under English law, but you can't get them for breaches of the Data Protection Act 1998, which was the legislation in force at that time. Individuals need to be able to show the damage and stress that they've suffered, and that is going to be fact specific to each individual. The damage that I suffer is not necessarily the same as someone else, and therefore you have to consider that on a case-by-case basis. So, but following on from that then, so can you use representative action? Well, the court said, well, yes, you can use it to establish liability. So has there been a breach of law? Here, has Data Protection Act been breached? You could do that on a representative basis, but you can't do that to establish damage and distress because, as we said in the previous point, that is going to be fact specific. So a court cannot say, assess damage and distress and the damages that are due to a class of 4 million people within that representative action. They will each need to do that either on an individual basis or as part of a group action which they've opted into. So that is very helpful in terms of limiting the scope of claims that may come out of large data breaches and a cyber instance, in that it means that claims for small amounts of money for when there's no actual loss suffered will be much harder to bring. And the other consequence of this, that Lloyd here was backed by financial backers who were funding this. The consequence of this case is it's much less attractive to litigation funders, because while they could bring the representative action for a claim for liability, they wouldn't be able to do it for damage and distress. So the actual reward for them of doing that, it just doesn't stack up anymore. So a helpful case in terms of limiting the exposure if you do suffer a large breach. We have a specific webinar on this with our litigation colleagues, which is linked to there, and we'll send that around after today. Just a couple of other cases to cover, so other things that you are of interest. So Warden versus DSG Retail, this was the retailer Dixon's car phone who suffered a cyber attack. The court there said that you can't bring a claim for under misuse of private information or breach of confidence following a cyber attack, because the misuse part of that requires some form of positive action, and there is neither of those principles impose a security duty on the entity. So the fact that you are subject to a third-party attack means that there is no basis for claim under either those torts. So again, that's helpful in limiting the ability of claims, and this all goes back again to after the event insurance and litigation funders and how claims can be constructed. There is an ongoing claim under that case for Data Protection Act breaches, but that is paused pending the outcome of the Information Commissioner's investigation into that. The second one there is Johnson v. Eastlight. Just an example of sort of thing that's going on. So an email was sent out with information on to a tenant with information of other tenants by mistake. It was deleted after 3 hours. An individual put in a claim for £3,000 worth of damages in the High Court and said that their cost for recovering that might be up to £50,000. Now, the court didn't strike it out completely, but they very reluctantly said, no, the right place for this is the county court, and your procedure where you claim through that. But what I wanted to flag in this is that in this case, this was someone whose information was in this file. It was sent to another tenant. The Housing Association has reported to the ICO. They had also very quickly told the other, the affected data subjects about this after the breach. And the ICO said, actually, that we don't think there's anything here that requires any further investigation. Yes, it was a mistake, but we're satisfied we don't need to take any further action. I just wonder whether in hindsight, the Housing Association perhaps it might be a little bit, regret how quickly it went out to tell individuals about this data breach, because had it not done that, the individual wouldn't have brought a claim. They wouldn't have known about this. They wouldn't have been able to argue they had suffered this supposed damage of up to £3,000. So a good reminder that if you do suffer data breach, just think carefully before you communicate with people. Remember that you only have to tell individuals about a breach where there's a high risk to them. And quite often in the early stages, we don't necessarily know what the impact is. And if you tell people, you invite claims like this, you may have managed to defend them, but there will be a cost to doing that. So a useful reminder there. And then the final one, Rolf, this is just an example of the courts now willing to dismiss exaggerated claims. Again, it was a fairly minor data breach incident. The court said there's no credible case here that distress or damage has been would be proved over the de minimis threshold. What was in the claim was exaggerated, and I think a good example of where the courts are now starting to toughen up in terms of their approach to some of these claims. I'm sure many of you will have received letters and things over the past week, well, that certainly around use of cookies on websites. There's been a lot of organisations getting letters demanding £750 and things like that. Well, I think these cases show that the courts are willing to take a hard line with those claims where there's no obvious or demonstrable damage of any substance. I'm conscious that this is a Q2, so just in terms of the other developments there, I'll let you go through this at your leisure, but just here's what else is being on in the background. We have the Age Appropriate Design Code. It came into force at the start of September, so for those of you who are affected by that, you should be familiar with it and think about what you need to do to comply. It is fairly broad in its application. This is all about online services and protecting the interests of children. Some more developments in the ICO and AdTech. We have a new bill in Parliament now on security of IoT devices that applies not just to manufacturers, but also to distributors and retailers, and also to people like house builders and property developers. A couple of recent data breaches there. I'm not going to go into detail, but you've seen the press coverage of that. And then the final one, I think, just to flag, is around the Employment Practices Code. The ICO has had a call for views on changes to that and updates. That call for views is now completed, and we're awaiting next steps in terms of the reform of that Employment Practice Code, which is now a good number of years old and predates GDPR, so well worth an update.
I'm conscious of time. There are a number of questions, mainly on what I've said about transfers, so I'll quickly rattle through very brief answers to them if we have the time. So is a TRA required if you're relying on an exemption? I think that means the Article 49 derogations. No, it is intended for Article 46 tools, but for example, if you're relying on explicit consent under Article 49, that explicit consent has to be on the basis that the individual has been informed of the risks of the transfer and why you're asking for that consent. And the answers to that are likely to come out of a TRA exercise. So I don't think the two can be totally divorced, but the TRA is intended for use in the context of Article 46. There's a question asked about how do you manage a transfer where the data controller is outside the UK EU, but the data processor is based within the UK and the process carried out in the UK with the data being transferred back to the data controller. So that's quite an interesting one because that touches on the consultation exercises being conducted by the ICO and the EDCB. The ICO has said in a UK context that it's minded to say that because the processor is not authorizing the transfer, so the UK processor is not authorizing the transfer, then the return of the data by the processor back to the controller that's outside the scope of UK GDPR is not a restricted transfer. Now that seems to me to be a very desirable outcome from a common sense perspective, but we don't know that that is the final view. It doesn't look like the EDCB guidance will give you that clear outcome. So that may be an area where there is some divergence. Another question about continuing to use the old SCCs before we get the IDTA. What measures should the parties take to satisfy themselves prior to relying on these for a new transfer outside the UK? I would strongly suggest that even though the TRA is not finalised, that you conduct a TRA exercise and then bolt on whatever additional things you think might be required to make your EU old style SCCs work, and then perhaps have a provision that allows you to migrate over to an IDTA or the wrapper that goes around the new style EU SCCs, if that's something that is actually comes out of the consultation. And if the all the data transfer stuff gets sorted, will we do a separate session on it before early June? I think our next scheduled update will be in May time, so we will try and make it early May if things are done, so that whoever is asking that question can get a little bit further guidance and an update. I think that's probably, given that we've overrun, that's probably all the questions that we have time for. I just want to mention a session next week, the fourth in our Cyber Byte session. Marie Berman from Dram Communication is going to talk to us about reputation management, what to do to manage your reputation in the event that you have a cyber incident. If you can join us, it is next Thursday, 16th of December at 12 noon. So please join us for that. Thank you all for attending. There is an online seminar. Could I please ask you to complete it? You finish off and go to your next appointment. It is very useful for us to help shape future events. From Martin and I think that's all. I'd like to say thank you and enjoy the rest of your day. Thank you.